Today we are delighted to have two of our law school professors with us, and it is great to have wonderful collaborative efforts between two campuses and then two colleges, School of Medicine and then the law school, and it's really great that we are here today. And then let me introduce our speakers. Professor Keith Robinson is a professor of law and faculty director for intellectual property, technology, business, and innovation at the Wake Forest University School of Law. He's a nationally recognized patent scholar, and then he is a renowned expert in patent law with a focus on emerging technologies like artificial intelligence, with over 70 presentations worldwide, and his research explores how legal institutions govern technology. And then our other speaker is Professor Raina Haque, and then she specializes in the intersection of law and emerging technologies, including AI, blockchain, and digital rights. Her work integrates multidisciplinary perspectives to provide practical solutions for complex technological challenges. As a former deep neural network developer under an NMR laboratory at the National Institutes of Health, she integrates multidisciplinary perspectives. We have incredibly talented and speakers today. Because we are in the School of Medicine and because this is law, are you going to present in English or in Latin?
Just in English.
I don't speak Latin, but I looked up how artificial intelligence is presented in Latin. Apparently, there is not a single translation.
Oh.
So Google recommends artificialis intelligentsia as a potential translation. They will present in English, so you can relax, and then together they will demystify patent law fundamentals, highlighting how they apply to AI, and then they will discuss core concepts like patentability criteria, the process of obtaining a patent, and the scope of protection it offers. The presentation will also explore specific challenges AI presents for the patent system. We'll all look forward to learning from you. Thank you.
Well, thank you very much for having us. It's incredibly exciting to be here. As I was saying earlier, this is a welcome break from grading exams to come and talk to you today about patent law. Just to clarify, one of the things that we're gonna cram in what is going to be a 4-credit course normally taught in law schools into about 40-45 minutes. You want to try and leave some time for questions. So this is a very sort of broad, high-level overview of the current state of the patent system. And Raina and I are going to go into some of our research topics that we've been exploring within the intersection of patent law and artificial intelligence. So that is the plan. I'm going to start by just sort of giving a broad overview. So patents are one area of intellectual property, which is sort of a broad topic that covers all property that is not tangible. So not land, not some physical thing, but intellectual property is that which can be and often is created wholly by humans, right? And so within our intellectual property system we have in the US, there are sort of 3 primary purposes of the intellectual property system. And underneath those purposes are these intellectual property rights that the law recognizes. So for example, trademark law is one area of law that protects the integrity of the marketplace. So when I look out and see, the symbols on your cups or the symbols on the back of your laptops, that's letting me know that those particular products were designed by that company, right? Second is expressive creativity like copyright law. So we have copyright law to protect works of art, things that are written down, plays, even choreography, things of that nature. And so that's where copyright fits. And then finally, under the broad umbrella of technological innovation, we have patent law and we also have trade secret law. Now, we're not going to talk a lot about trade secret law today, but I do want to mention it because that has become increasingly important, especially for companies that want to protect their know-how, right? And so for any of you that have been following sort of the development of semiconductor chips as it relates to artificial intelligence, a lot of times for these companies that are engaging in industrial espionage, they can capture the chips and get sort of these high-powered chips that they're not supposed to have access to, but they don't have the know-how that goes into actually building the chips themselves. And so for a lot of times, just having the chip is almost useless to them, right? Mm-hmm. And so the trade secret law is what protects the know-how. And this is where it gets more complex, right? Because there's overlapping protections within our intellectual property system. With respect to utility patents, and utility patents are patents that cover processes, machines, manufacturers, and compositions of matter. We can protect those types of inventions with patents and also trade secrets. And a lot of times you'll see companies making that critical decision: do we disclose this information or do we keep it a secret, right? One of the more popular trade secrets that you might be aware of is the Google algorithm, or the original Google search algorithm. Google made a intentional decision to keep that algorithm a secret, right? To not disclose it. Design and patent protection is another area where we see it, and this applies a lot, and we see a lot of design patents covering ornamental designs, such as the design of your laptops. Medical devices sometimes are covered by design patents as well. And there we see the intersection of not only design patent law, but trademark law and copyright law as well. So while we're going to specifically focus our discussion on utility patents in this discussion, there are sort of broader implications that some of these intellectual property protections can overlap and interact with one another. So before I turn it over to Raina to talk more in depth about patent law, just want to sort of, again, give you sort of a broad overview of trade secret law, because in my experience and practice, one of the initial decisions that a lot of companies will make is the one that I talked about with Google is, do we keep this information a secret, or do we disclose it in a patent application? And once you disclose that information in a patent application, for most patent applications, those applications are published. And so that information becomes public knowledge. And so one thing that you want to decide early on is this a secret sauce that we want to keep a secret that gives us a competitive advantage? Or is this something that we want to obtain a patent on and disclose, but make use of the exclusivity that patent gives us for the next 20 years or so? Right. And so normally a trade secret is something that is of value, can be almost anything, something of value that you keep a secret, or that you use reasonable methods to protect and keep a secret. Right. One thing might be, hey, look, only certain people have access to this lab and this specific technology. That is a way of keeping that information a secret. And so with that sort of setup, I'm going to turn it over to Raina to sort of talk more about, go into more detail about utility patents themselves and explore sort of the framework for our patent system that we have currently.
Okay, all right. So patent, what is it? So I've been a patent attorney here in this community for a while. So I've worked with researchers even before I started at Wake Forest. And what's so beautiful about being a patent attorney is that I'm usually the dumbest one in the room, right? Because my clients are much smarter than me. But what's really neat is that I get to communicate about patent law to them. So I make a lot of use of analogies here, and I also get kind of goofy. So forgive me for that, but it might help you remember some core concepts from which so many other things can be derived, right? So a patent, what is it? Well, the interesting thing about a patent, which a lot of people don't realize, it's an exclusive right. What that means, it's a right that can be enforced by the government that gives its owner the right to exclude others from using, offering to sell, selling, or importing a patented invention in the US for a limited time. So a lot of people who would come to me would come with the assumption that if I have a patent right, I have an affirmative right to do or make something. But you know what? There are patents granted even on illegal things. So it's not that they have a positive right to like make this thing that'll help you trip on mushrooms. No, it's that they have a right to exclude others from doing or making that invention, okay? So first of all, it's an exclusive right, all right? And it's a really broad exclusion, right? It's all these things: selling, importing a patented invention in the US for a limited time. Okay, so that's what it is, but then why does the government give it? And now this is really the key idea from which we can derive so many other nuanced things about patent law. Why would the government give this right of exclusion? And why do I have a lollipop in this picture? Any ideas? Any ideas? Why would you connect a lollipop to this patent right that the government gives?
So they had a patent on lollipops.
I like that. Anyone have kids? When do you promise your kids a lollipop?
Behave.
Yeah, you're trying to affect behavior, right?
Yeah.
Get them to do something good. Okay, well, yeah, the patent provides, this idea that we'll provide inventors with this exclusive right to their patented inventions to encourage them to promote progress by reducing competition for them, okay? So we're incentivizing them to promote progress. But what does that promotion of progress entail? It means that we want them to give up their secrets. We don't want people to die with their secrets of how they made this, right? We want that to be coaxed into the public so that becomes public knowledge. So that's the trade-off here, you know? It's not like we're rewarding you for being a genius because you're a genius. No. There's something we want from you to promote the public good, okay? So that's the lollipop we're giving. The possibility of reducing competition for you, but you have to disclose for us your technological innovation. So we encourage early disclosure of useful inventions, and in return, we eventually allow the public to practice those inventions after the patent term has expired, okay? So from this principle, I don't know, do we have any physicists in here? Mathematicians? People who've written proofs?
Yes.
From this, you can derive so much else about patent law, okay? All right. So we serve the public interest in the progress of science and the useful arts. This is actually the phrase that's in the Constitution. From this phrase, all of IP law really can be derived in the Constitution. So all our statutes, all our regulations are derived from this phrase in the Constitution, right? And I think James Madison is credited with that phrase, okay? All right. Okay. So let's talk about getting a patent. Let's talk about the process and the requirements. And in that, okay, we have these are great illustrations that I credit Keith with. Okay, so starting with 2013, we moved to a system where the presumption of superior patent rights or superior rights in an invention is the person who raced to the patent office with the patent application and got there first, okay? It's a first to file system. Before 2013, it was a first to invent system, right? How many of you know about the Woonvac? Okay, yeah, okay, you do. So that's another story for another day, but it's an interesting one. Okay, so a first to file system starting with 2013 with the American Invents Act. So we raced to the patent office saying, hey, look, we've got this invention, United States Patent and Trademark Office, which is our regulatory agency for handling patents and trademarks. We've got this invention. We have this patent application, okay? The office there has these examiners. These examiners are specialists with technical backgrounds. That's one of the requirements we currently have. Historically, we didn't always have that requirement. And they have technical backgrounds, and based on what their technical background is, they're housed in different areas of the USPTO. And these are called art areas. So if your invention mostly has to do with mechanical arts, you'll go to, your application goes to a specific office there. And so on, right? And an examiner has that background and field of study. They're not necessarily lawyers, right? But they do have that technical background. Okay, so the examiner is going to do an examination on a couple of things, and I'm going to talk about these. They're going to examine your application to see if your claimed invention meets these criteria: subject matter, utility, novelty, obviousness, and disclosure requirement. Okay, and I'm going to go through these with some of you, and Keith will go through the last one. Okay, now assuming you get through all of those just fine, and your claimed inventions go through all of those just fine, you get this exclusive right, a patent right, which is essentially a monopoly, for 20 years from the time of that you filed that application. Okay? So, just from this alone, even though I haven't gotten very deep here, what kind of lessons can you divine from this? One, if you've got a claimed invention and we have a first to file system in the US, do you want to go around talking about your invention to everybody? Why not?
You'll be the first to file, right?
Yeah, what do you want to really, have a competitor or someone else sneak into the office before you? Then, you've got to prove that, no, actually, So, these are just some smart things to have, right? The other thing, too, is be clear about when you're inventing, if you're the inventor, and if you're the inventor, if it's your invention or your employer's invention, right? So when we sign employment agreements, too, that's something to keep clear. Are you doing this on the job? Does it belong to your employer or is it yours, right? So even before I've gone into anything, there are some lessons to divine from this, all right? Would you like to add anything, Keith?
No.
Okay, good. Okay. Yeah, so many of you may know this. I got a thumbs up from somebody. All right, okay. Is anyone keeping track of if someone in the, I don't really know how WebEx works, but if anyone has questions, I guess we'll take those towards the end and I'll figure that out then.
Can you see the chats?
Yeah, we can do questions at the end.
Okay,
Yeah.
sure. Okay, all right. So, yeah. So again, remember, it's just an exclusive right. It's not like once I get a patent, the government's giving me this huge sack of money. So don't think I'm getting this pot of gold at the end. I still have to do everything. I still have to build a company. I still have to market. I still have to do everything, right? So remember that too. That's a common misconception that getting a patent means big bucks. Like I say to a lot of people, there are a lot of people who have lots of patents and no money from them whatsoever. There are lots of people with no patents and lots of money from the things they've created, right? Okay. All right, so let's describe the requirements for patenting and also apply them to AI-related inventions, right? We're all in care, so. So we've talked about this, or we mentioned this first one, subject matter eligibility. So in order to be subject matter eligible for patent protection, the invention needs to be a process, machine, article of manufacture, composition of matter, or improvement to processes, machines, articles of manufacture, or compositions of matter. This is according to this statute, 35 USC section 101. Of course, like everything in law, it's written one way, but cases show up that kind of confuse us. So the Supreme Court's determined that the following inventions are not patent eligible: laws of nature, natural phenomena, and abstract ideas. And things that have especially fallen under scrutiny are business methods, biotechnology inventions, including gene patents and diagnostics, and medical treatment methods. That's not to say categorically these aren't patentable, but they have fallen under scrutiny. Like when? Like, for example, if a gene is isolated, that isolated gene is not necessarily patentable subject matter. Why? Because that could be considered natural phenomena, right? Or an algorithm, right? So an algorithm can be considered also like natural phenomena or an abstract idea too. So now you see, those of us who are in AI, even if we come up with this brilliant neural network, and we've made our biases just perfect, that's not necessarily patentable subject matter. That alone isn't. So now you can understand why people might choose the trade secret route instead of the patent route, or not very much leaning heavily on the patent route because it's not available. Although Keith can talk with more nuance about those decisions. So this is really important to know. I remember early on I was talking to a data scientist at a rideshare company, and I won't tell you which one, but this was when they were starting to get big. And I was saying, well, do you have any patents? And he said, if anyone can figure out our algorithm, good on them. It's not going to happen, So they chose to keep it trade secret, right? The weakness with trade secret, though, is that if someone can reverse engineer and figure out that trade secret, you have no legal recourse, right? So that's the thing. So patents are very strong, right? But then there are these hurdles you have for even having something fall within patentable subject matter, okay? All right. Now, novelty. So an application for a patent can be invalidated if that invention existed in the world before. So, and things that existed in the world are called prior art. And I want to tell you that publication doesn't mean that, oh, this had to be in the world with peer review before. Publication has a very, very low bar. It could be like in a library in some village in Japan, remote village on some island off of Japan, and that's considered publication because technically it's available to other people in the world, okay? Even if it's just in print form. So again, if Dr. Gurkhan tells you about the wound vac history, like that's an illustration of when prior art can come back and invalidate a patent, right? Because even though there was a patent that was considered valid for so many years, someone comes and says, actually,
Do you want to tell them? Because I
know the contours of it, but yeah, Wake Forest Baptist had a patent on something called a wound vac for many, many years. I don't know like all the details, but then it was found that there was some earlier written kind of invention that described in insufficient detail something similar. It never had a patent on it, but it was out there in the world that pre-existed this wound vac. And so I think a competitor raised this issue and then invalidated Wake Forest's very lucrative patent, So this really happens, right? And this is why we have to care about doing our research before, or while we're developing inventions and while we're going down the patent route, right? Okay. So if you know details, yeah, definitely that's a case to look into. Okay? Okay. So, something's prior art, even if few people saw that prior publication. There is an exception, though. If you yourself published something about it, but you did it within 1 year before your application, then that's okay. All right. But the counterpositive to that is that if you 5 years ago published about this this invention in a paper, and then you wait 5 years to file your application, too bad, so sad. And this goes back to that first principle we talked about. Why does the government need to coax you to give up something to the public if you so freely already did it, my dear, right? You already gave it up, right? So we don't need to give you a lollipop. Okay? That's the idea. Okay? So this is like, this is the big question with these generative AI models that we have coming out now. This is a question. We haven't yet answered this in law. But could these outputs of generative AI models, if they are somehow still findable, could they themselves be used as prior art? So could they be used themselves to invalidate applications that are filed later? So could you imagine competitors using that aggressively? Generating all that they can just to use as a sword later, so that their competitors can't file applications on those, even if they themselves have no intention, to develop those technologies. So that's, these are some of the things that we patent scholars are looking into. Also, other companies are worried about too. Okay. And also, with advanced AI searches, can they be used aggressively to find prior art? That was even a concern, before generative AI, of course. Like now that more things are being digitized, can we find prior art from anywhere in the world? Okay. So that's about prior art. Now, non-obviousness. This one's tricky in that one of the big hurdles for proving that your invention is patentable is that proving that this claimed invention is a non-obvious improvement over things that not only already exist, but kind of the concepts that could be combined that are already in existence. Okay, so a claimed invention must be non-obvious to a hypothetical person of ordinary skill in the technical field of invention. Okay, so this determination is based on these inquiries: the scope and content of the prior art, so things that are already published and available, the level of ordinary skill in the technical field of the claimed invention, and the differences between the claimed invention and the prior art. So, why this is wordy is because it's taken from case law. Okay, so teachings from multiple prior arts documents and other items may be combined to show obviousness. So it's not just about what's literally out there and published, it's even about the combination of things that are out there and published. Like, would a person having skill in that art field, would the other, biotechnologist or biochemist reasonably put these two things together and be like, oh yeah, that's an obvious combination of those two things, So that's tough, right? Hindsight bias is something we worry about here. And, this is where I tell inventors and researchers, when you are inventing something, keep a log of all the problems you run into. Because when your patent attorney starts writing the patent application, for sure, the examiner is going to be like, this is obvious, this is obvious, this is obvious. And we'll be like, no, this wasn't obvious because we ran into this problem. It wasn't just easily combining this and this. Here are the problems we had, and here are the clever strategic ways we had to get around them. This isn't just 1 + 1, So keeping a log of how you invent and the strategies the problems you came and ran into and how you got over them is really important, especially for arguments against obviousness. Okay. So, oh gosh, I don't know why I cut off there, but generative AI models, isn't all output, the idea is, isn't all output some obvious derivation of training set input if we accept that advanced neural networks kind of do this kind of slicing and splicing and maybe some but not very advanced advanced synthesis. So that's a question. Are we going to start accepting kind of the thresholds of what generative AI do? And so then, even though this before seems remarkable, later on, not so remarkable. This is obvious to us, where before this was remarkable, right? That's like a paper I've written recently. Okay, so then also, could aggressive competitors stock prior art into the public sphere to render most generation obvious too? These are some things we're concerned about. Okay, all right. So I'll let Keith take over.
All right, so hopefully everybody's still with us so far. So one of the things that Raina said that was really important about non-obviousness is that is one of the more common problems that inventions run into. And I have some data that I'll share with you that backs up that contention. So generally speaking, that is probably the biggest hurdle that you have to overcome at the patent office to obtain a patent is showing that your invention was not obvious. So one of the other, and Raina talked about this earlier, it's a quid pro quo with the patent office, right? In return for disclosing your invention, the United States government gives you a 20-year quote unquote monopoly to exploit that invention. Well, one of the things that the patent office requires is that you describe your invention in enough detail. And so this is known as the disclosure requirement. And there's sort of three separate requirements underneath the disclosure requirement. The first one is called written description. That means that if you say that you invented a new semiconductor or a new microprocessor, you have to describe that microprocessor in the description of your invention. They have to match up, right? So you can't say that you invented one thing and describe another. Second, you have to enable one of ordinary skill in the art to make or use your invention without what's called undue experimentation, right? And so you can't, I explain this to my students, is you can't hide the ball. In that patent application, you actually have to make sure that someone at your current level, whether that be a PhD in electrical engineering or biomechanical engineering, can pick up your patent, understand what you invented, right? And then go into a lab and create that invention, right? Without, taking years and years of experimentation to do it. So you do have to disclose your invention in sufficient detail. And the third requirement is that you disclose the best mode. Now, this requirement is muted somewhat because of some other provisions with respect to litigation that would be on the scope of this talk. But basically what best mode means is, what's the best way to make your invention, right? There might be several different ways you could do it, but tell me what the best way is. One analogy I use for my students is it's almost like a recipe, right? Part of your patent application has to be a recipe for your invention, right? So the written description, let's take a cake, for example. Written description is going to tell you what type of cake you're making, and you're going to claim that type of cake. Enablement is going to give you the ingredients, the recipe for making the cake, right? And then the best mode is, well, what is the best way to make this cake, right? And I think about my mom. She makes a really great pound cake, but she does not do a good job of disclosing. If she was trying to get a patent, she would not get one because she does not disclose all the details needed, right? And my younger sister, has tried many times to make the cake with the ingredient list that my mom gives her, but yet there's something missing, right? And so my mom is not doing a good job of disclosing the invention, right, of her delicious cake. So exactly. So this is a critical component of the invention process, is that you need enough detail in your patent application to satisfy this last requirement. One of the things, current research projects that I am working on now, is looking at the written description and enablement requirements with respect to machine learning patents, right? And so we all know that machine learning is an important part of sort of training neural networks to identify and use various artificial intelligence applications, right? And so one of the USPTO has put out many requests for comments over the past 5 years or so with respect to artificial intelligence inventions. One of them in 2019, they talked about specifically the written description requirement and the enablement requirement, right? And one of the things that the USPTO is worried about is because a lot of these artificial intelligence inventions are quote unquote black boxes, are these patent applications satisfying that written description and enablement requirement? In other words, can someone pick up these patents and duplicate the information, right? In a research field, this would be analogous to replicability, right? Can I replicate the experiments and the research and actually produce the results that were published in a particular paper? And so the USPTO was incredibly worried about this. And so in response to the request for comments, they got varying responses. Some experts in the field thought, no, this is not a big issue. Artificial intelligence patents, you can pick them up. They're described well enough. It's not a big deal. But other experts thought, no, this is a really big problem because it's been in the news, there are certain artificial intelligence applications where even the researcher or the creators said, we don't know how it worked, right? It came up with the solution. We have no idea really what's going on inside, and it is a black box to us. And so one of the things that my research and I decided to do is, well, let's look at these machine learning patents to see whether or not they are adequately described according to the written description and enablement requirements under the U.S. Patent system. And one of the interesting things that the USPTO has done in the last 10 years, I think is really useful, is they've published a lot of data on the patents that have been granted. And so one thing that we were able to do is to conduct a secondary data analysis on a unique patent AI data set that the USPTO created. So these are over 13 million patents and patent applications that are directed to some sort of AI invention. Now I have a slide that sort of separates the different categories, but the USPTO provides this for free. So anyone can go on the USPTO website and download this data set of artificial intelligence patents. And so we decided to use this artificial intelligence patent data set and look at the other thing that's public record is when you file a patent application, the back and forth between you and the examiner, the arguments, they are public record for the most part. This is called a file wrapper. And so at any point during the patent prosecution process, if you're interested in a particular patent, you can go on the USPTO website and look at what problems it's encountering, what it's running into. A lot of times what patent attorneys do is they'll go look at similar patents to see what the arguments are that are being made in that patent to help them with their arguments. So it's a very important resource that's made public. And so we looked at the public information on machine learning patents in this data set. And what we found is that the disclosure and enablement requirements were very small. So only 4% of the patents that we looked at and studied had a problem with written description or enablement, according to the patent office at the time. And this was kind of shocking to us. We thought there would be a greater percentage. What we did find, and this goes to the information that Raina was talking about, over 50% of these patents had a non-obviousness problem. So 103 is the statutory section for obviousness. So over 50% of these machine learning patents were rejected at the patent office for being obvious, right? Then you see 43% for not being new, novel, right? And then 38% for being unpatentable subject matter, and then a lesser percentage for indefiniteness. So this supports what Raina was saying earlier, that the biggest hurdle for a lot of these patents, and this is across the board, this is not just artificial intelligence, but in general, is non-obviousness, convincing the examiner that your invention would have been obvious to one of ordinary skill in the art. It's the patent data set at the USPTO is separated into different sort of technological categories. So again, our research is focused on machine learning there. You can see that the area of evolutionary computing, that area right there has a higher rate of rejection under written description and enablement. Evolutionary computing that area is a lot analogous to antibodies, in that there are several cases recently where an inventor is trying to get a patent on antibody or antibody technology. And what the court has said is the less predictable the technology, the more you have to disclose about it in order to overcome this written description and enablement problem. So if it's an invention in an area like electrical engineering, physics, or mechanical engineering, where we kind of understand the rules and we can explain what happens, you don't have to disclose as much. But if you're dealing in an unpredictable area like antibodies or artificial intelligence, you might have to disclose a great deal more information. And so just to finish here, I'm continuing with this research and plan to do a comparative analysis. Hopefully, we hope to have like a finalized paper in the fall. I would be happy to share it with anyone that's interested in sort of seeing this research and where it goes. And if anyone has ideas for further research in this area, happy to have discussions and talk with you about that. And so now I'm going to turn it back over to Raina to finish our discussion.
Yeah, so again, I do goofy things, but one thing I wanted to emphasize to you all is that, like with so many things law-related, law doesn't occur in a black box. Often, like, the public is invited to give their opinions, and that even occurs in the patent application process. At some point, even when the patent application is in the office, the application is disclosed to the public for people to write to the office and say, like, hey, I got some issues with this application. There's some prior art out there, or I think this is an obvious invention. So there is that opportunity to step in to the patent application process by these third parties. Okay, so that's it's called a pre-issuance submission. And even after a patent is granted, there's the opportunity, like we discussed with the wound vac, for people to come in and validate patents. So, these are just things to be aware of. And that's why you really want to pay attention to all these criteria about patenting and do your due diligence throughout the inventive process, right? And with AI, there are these unknowns, right? That we discussed a little bit earlier too. But like I said, law doesn't happen all in a black box. There are these opportunities for you to write to agencies, to legislators, to be like, hey, as you are figuring out what to do with this boom and artificial intelligence capabilities that are ubiquitous now, consider my perspective as a researcher. And there are opportunities right now to write to these agencies. Like, those comment periods are right now. So, like, really, they're looking for your viewpoints. So questions?
First of all, thank you. This is such a treat. I have 8 patents under my belt, but I learned so much from this presentation. I wish I had had this opportunity many years ago. It would have clarified a lot of things for me. I really, really appreciate it. This is a complex subject, but you managed to present it in such a nice, understandable manner. So that is really great.
Well, even if we didn't, we'll take questions now. So,
Questions?
Yes.
Yeah. So I have a question related to the patents of those softwares. Because we all know that for hardwares, like for example, Dyson's vacuum, everyone can buy it and separate it apart, know how it's designed. But the software, like an AI algorithm, uh, like some other people can easily just train the same model and then wrap it up like a product and then just sell it. Nobody know how it designs inside. So the patent owner won't be able to find that they are like using my patent for free.
Oh yeah. So enforceability.
Yeah, so that is a risk that when you are designing your patent portfolio and your strategy, that is one thing that you do have to take into account is, are we able to discover infringers, right? And so you might suspect, patent litigation is very expensive. The average litigation in the US is somewhere between $3 and $5 million just to sue someone for patent infringement. And so one of the things that is very difficult when it comes to software patents and process patents is discovering whether or not your actual process or software is being used, right? And so there is some research out there that suggests that the value of process patents and software patents is a little bit lower than you might have over machine patents or apparatus patents for that reason, because you might have a patent on a process, but it could be easy to design around that process. So I could skip a step or not include a step or do it some other way and accomplish the same goal. So I would say, to answer your question from a strategic perspective, you got to really think about, are we going to be able to discover whether or not someone is using our algorithm or our process and successfully sue them for patent infringement before you think about investing, to get a patent application on something in that realm of technology. I think the average cost would be could be anywhere from $10,000 to $30,000 to obtain the patent, right? And then you're talking about another $3 to $5 million for a lawsuit. So it's really got to be on transformative, important, foundational technology when you're starting out. That would be my opinion.
The other thing to remember too, I think a lot of people I would meet with would assume that they're the inventor, they're the company owner, they're in it for the long haul. But oftentimes, like you are getting the patent to sell it off to someone else to handle the business, right?
Yeah.
And you're happy to do that. You just want to make sure that you are selling it for enough so that you're happy to do that, right? And make it someone else's business problem to figure out how they're going to enforce the patent and stuff. So, yeah.
Yeah, to find someone with the money to protect.
Yeah, exactly. So I think we got there was a paragraph question. I'm not as familiar with WebEx, so let's see how I could find the text.
Do you want me to read it out?
Can read it for
Okay.
you.
Oh, thank you.
So this is says like Dr. Flu. Sorry if I said the last name wrong. But so thank you to the presenters. The background he has is in medicine.
Looks like he is with us.
Yes,
Are you in a position to be able to turn your microphone on or camera on and then ask that question yourself?
I appreciate the presentation, but I wasn't expecting to be on with you guys. But
That's all right.
and I think you take boards, like we have boards in our own stuff, and I think with patent law you have to go through rigor to be able to practice in that field. So trademark and patent, I thought of them as being separate, but for you, is it separate or is it the same concept? Like if I have a trademark, do I have a patent or no?
No, I think in other countries, they're kind of collapsed, but in the US, they're distinct.
Yeah, so they're distinct intellectual property rights. Part of the confusion, I think, stems from the fact that we have our USPTO is Patent and Trademark Office, but they act very, very differently and separate. So you do have to apply for a trademark that is examined by trademark attorneys, and you do have to apply for a patent, which is examined by patent examiners. But the rights are separate and very different.
A couple follow-up questions. You know, and I'm not sure how to even phrase it. With the Cures Act, we're required to share with patients what we know about them. Like, you came to the visit today, this is what happened during the visit, these are your labs. And what's happening is quite a lot of the AI that you're describing, all that type of technology, essentially is using that data where the patient doesn't know about it and is, creating modeling, whatever it may be, even de-identified, but they never gave permission with awareness. Like, they may have signed a form in the visit a year ago that said, sign here, and they haven't read the document. Is there within the patent thought process research the consent of data generated, not consented for generating technology? Is there any thought process? Is that like unethical kind of thing or allowable?
I think like it happens to be that right now I'm going through the SIP stuff for cybersecurity law. So I think it's safe to say that's more in the realm of cybersecurity and privacy law. Like I said, patent stuff is a little bit more technical, and even people get patents on illegal stuff. So like that's not really in the realm of patent law, but people are thinking about it. Just it's kind of outside the field of like core patent law.
I would say, as a lawyer, I would look at the recent settlement that Johns Hopkins had to pay to Henrietta Lacks and her family, and I would be very deliberate and very detail oriented in making sure that the patient knew exactly what information was being collected and how that information was being used. And if you look at that as an example, I assume most people are familiar with that Henrietta Lacks example in the HeLa cells. If you look at that example, that is a situation where that's sort of like the worst case scenario from the perspective of the medical professionals in the hospital that was involved in that case.
There's a great book about it.
Yeah. But like it might be something you actually want to talk to counsel about at the hospital too. And I guess we should have given the disclaimer too.
Right.
We're not anybody's lawyer here. And that's pretty outside of our field of expertise.
But yeah, that most of that information those issues should be covered by the disclosures that the hospital makes and sort of the contracts that the hospital enters into with the patient.
But that's a big ethical question, and we talk about that with our students too. Just because someone signs something doesn't mean they understand it.
Right.
So that's a big, huge ethical issue. Yeah.
I have two questions, but I'm going to give you only one, which is international aspects. So let's say within Advocate, we're local, but there's England, there's Australia. I mean, it's going to be time, if not us, someone else is going to expand out in that realm. Patent law. Are you guys thinking, or is there any research in terms of the strategy about where you're going to get your patent? So I know you're thinking U.S., but the world is bigger than that.
Yeah.
Any thoughts about international aspects about what you shared? And thank you.
There are several countries. So if based on the clients that I've had experience with, there are several countries where you want to think about filing. Now, understand that patent law is territorial. So just because you have a patent in the U.S. does not protect you anywhere else in the world, right? But generally speaking, Japan, Korea, China, maybe Europe. Europe, you can get like what's called an EPO patent, so you can get a patent that covers most of the European countries. And then you might think about maybe there's a country in South America or Africa that you also want protection for. But generally, where are you going to sell the product? Where is the product going to be used? Where is the product going to be made? Right? Those are the things that you want to think about when you want to identify where else you might want to file for patent protection in those countries. Understanding that there are situations where you can get a patent in the U.S. and it might be more difficult or easier to get a patent in another country, but each country has, generally speaking, its own set of rules, and so you need to engage with a patent attorney in that country that's trained in that country's laws to help you navigate that particular patent system.
Maybe a related topic, just it's in the news these days quite a bit, and it will be good, of course, for you to stay away from what is in the news, but and then not comment on a specific case. But there is this question of fair use, just in these algorithms, and I think it's partly related to copyright law aspects. So, what is fair use, and how should we understand and interpret it within the context of AI? Because just some of the algorithms we develop need to learn from something, and in those cases, what could be fair use and what could be the opposite of fair use?
Yeah. Do you want to?
I can take it first.
Okay.
Well, first of all, like you say, it is hot right now because it's not 100% clear. Like there are lots of arguments on both sides, and that's very compelling. Some saying this is not fair use. Others saying, of course, this is fair use. Some saying copyright isn't even the right domain for understanding this problem at all. So my perspective is it's pretty nebulous, but so that means it's risky either way. It's risky either way, that there's an opportunity cost or there's actually a risk, like a legal risk also. So, yeah, I think, unfortunately, that's the best I can tell you. And that's why I'm researching that actively right now, and that's the best I can tell you.
So fair use is a defense to copyright infringement.
Yeah.
Right? And so a good example of this is one of the ways in which you can use the fair use defense is to say, well, I made a copy of your work for educational reasons.
Right.
This happened to me recently. So I recorded a copyright class for my IP class, and I used a song, a Roy Orbison Pretty Woman song, in the video that I made for my class. I put it on YouTube, and I got a takedown notice. As YouTube said that you made a unauthorized copy of the song. And there's a mechanism in YouTube where you can reply. And I said, no, this is fair use. I am teaching a class. I'm actually teaching about copyright law. Right? How meta is that? I'm teaching about copyright law, and you're taking down my video. And so I was successful, and they allowed my video to stay up. But so what OpenAI and some of these other AI companies are saying is they anticipate that they are going to use the fair use defense to defend themselves against all of these copyright infringement lawsuits that companies like the New York Times and others are bringing against them to say, look, yes, we made a copy of this information, but it was within the bounds of fair use. We're using it for research. We're using it to further discovery. And the most analogous case I can think of where these tech companies were successful was the Google Books case, right? Where Google Books said, well, no, we made copies of almost every book in existence, but look at all the cool things that we did with it. Now they're all searchable, right? And so this is what they call a transformative use, right? And Google Books was successful in that case in asserting a fair use defense. And so a lot of lawyers watching these lawsuits anticipate that OpenAI and Anthropic are going to make a similar argument saying, yes, we made copies of all these books, but it transformed them into something you could talk to, right? This is not reading the book. This is actually interrogating the book, talking to the book, having a conversation. And that is a transformative use that's covered by our fair use doctrine. So, it remains to be seen whether or not they'll be successful or not, but it'll be probably, it almost inevitably will go to the Supreme Court.
It's
and
not settled,
it'll be a huge case when it comes before the court.
Wonderful. It's 1:00. And just, we can continue this
forever.
discussion, and hopefully this will not be the last time that you are here. And then that's what we will talk about, and then
Yes.
collaborative opportunities, and then this relationship. Because I wish we could say, well, this settles everything. We know everything. we know everything about patents and AI, and then just read these slides, and then you are good to go. As long as there are open questions, I think our dialogue needs to continue. Thank you so much again for joining us, and let's thank them. Thank you for coming.
Yeah, thank you guys for coming.
Yeah.